各位好，欢迎来参加今天晚上的这个 webinar。我们再过1分钟，我们正式开始。Hello everyone, we'll be starting in 1 minute. Thank you for joining our webinar this evening.你好，欢迎大家，我是四百库的主席 Robert Lewis 吕立山。今天晚上非常高兴能欢迎到我们这次的这个 webinar， 我们这个泰国还有越南的这个律师朋友们。我们今天晚上的 webinar 我们就是全部用英文，所以我就是先就是做一个介绍，然后呢就是让我们的贵宾他们来介绍他们自己的这个职业背景，还有他们的今天的话题。Good evening, everyone. Very pleased to have you join us for our webinar. As you know, at SIPAC, or Sibaiku, our mission is to help promote 涉外法治建设, the development of the international legal system or infrastructure in China, and a main part of that is to help improve and promote engagement between top lawyers in China doing cross-border legal work with our friends around the world. And tonight, I'm very pleased to welcome some of our friends from our original member firm from Thailand and ASEAN, which is the Tilleke and Gibbins firm, which is the leading law firm in Southeast Asia with offices across several countries in the region. And their two principal offices, I will say, are represented here in tonight's program. We're very pleased to have Noparat from the Bangkok office in Thailand and Woyupan from the Hanoi office in Vietnam. And as you can see, and as per our original promotion of this event, they'll be talking about exploring data protection laws in Thailand and Vietnam. As we prepared this webinar and we were discussing topics, it became clear that Chinese companies investing in or conducting business in Thailand and Vietnam, one of the most common questions that they had related to data protection, legal compliance in these two Southeast Asian countries. So we're very pleased to have Noprat and Weipan to introduce not only what the laws are, but key strategies and best practices. With that, I will allow Noprat and Weipan to introduce themselves and their topic and to go from here. Thank you very much.
Thank you, Robert, and good evening, everyone. My name is Noprat. I am a partner and head of the privacy and cybersecurity at Thailand Gibbins, based in Bangkok office. And today I'm here with Ms. Welpen. So, Ms. Welpen, would you mind to introduce yourself first?
So, ni hao, my name is Welpen Pembichai, and I'm a Thai qualified lawyer. I have been practicing law in Vietnam for 10 years. My major practice is technology, media, and telecom, where I head the practice group in Vietnam. And also one of the main practice group that we in charge is also data protection. So very pleased to be with you tonight in the evening. So we would love to share our experience with you.
Yeah. So as Robert mentioned earlier, today we will explore data protection law in Thailand and Vietnam and some key strategy and best practices. So this is our main topic for today. And today we will divide our presentation into sections. The first section will provide you with the overview of the key aspects under Thailand and Vietnamese data privacy laws, including key definitions under the law and also extraterritorial effect under the laws as well. And for the section 2, the second sessions, we will talk in more details on key issues or key concerns, including the strategies and best practice to handling such key concern and key issues. So it will include the data minimizations requirements, consent requirements, notification requirement, and etc. So let's begin with the first one. So the first sections. Okay, this is us again. And okay, this is the first sections. So we will start with the key definition first, because this is very important for all of you to understand the key definition under both laws. So I will explain on the Thai perspective, and Ms. Walpen will explain more on the Vietnamese side. So we will start with the data subject. So as you may know, the laws tends to protect the rights of the individual. So the data subject means any individual, right? No corporate entity will involve or protected under this law. And this law will focus on the individuals, and we normally call data subject in our law. And normally the company will handle any data of data subjects, and data subject can be any persons, and normally it can include employee, job applicants, customers, individual suppliers, or individual vendors, and it also includes authorized person and contact person of the corporate entities. This is very important one, because some of our clients still think that the authorized for example, authorized directors or the director of the company does not include in this law, which is not correct, I would say. So the contact persons and director and also authorized director of the company also under the protections of this law. Next, we will talk about the definition of personal data. So under both laws, we have two sets of data. The first one is general personal data. So it means any data pertaining to natural persons, which enables the identification of such person with whether directly or indirectly. As you may see on the screens, the definition is quite similar to the GDPR. But for the category, a special category of personal data is quite different. So under Thai law, we don't have a definition for special category of personal data or sensitive personal data. We do have just an example of the sensitive personal data mentioned in our regulations, our laws. But for Vietnam do have definitions. So I will let Walpen explain a bit more on that definitions. But for Thailand, normally the company as a data controllers may collect health related data from its employee, for example. This is considered as sensitive personal data, and you may need to have more care when handling the sensitive personal data, which I will explain in more detail in the second sections, why you need to take more care when you're handling the sensitive personal data. So, Walpen, please go ahead for the Vietnamese perspective.
Yeah. So like Nopala just mentioned, right? So in our jurisdiction, and especially for Vietnam, right? So we have two types of personal information. So first one, the basics one, you can see in the box, right? There will be the really common, kind of basic information. But what we would like to draw your attention to is about the sensitive personal information. Especially under Vietnamese law, we have a exclusive list of what could be considered as sensitive personal information or not. And you can see here that it could include the political will, the religions of the person, the medical record. But just be careful a little bit about the medical record, because not every kind of health data or medical related data will be considered as sensitive personal information. Only the data that contain in the medical record issued by the healthcare establishment, like the clinic or the hospital, it will be considered as sensitive personal information under Vietnamese law. So if you have an employee, right, and then you collect some information about their blood group or whether they have any special health condition, those one will not be considered as sensitive personal information, only the one that provide in the medical record. So this is the key information that I would like to share with you.
Yeah. And again, any data can be considered as personal data. So it must be first identify whether or not the data that you collect consider as personal data and or sensitive personal data. This is very important because if it fall out under it, if it's not like subject to personal data, this law will not cover, I would say. So for the next definitions for the data controllers and data processors, this is the key, I would say the key, like key main persons under the law that the law tends to govern them, I would say, because they have the data controller have the authorities to control or determine the processing of the personal data. So there are certain set of obligations between these two roles, data controller and data processor. But first, you need to identify whether or not you are data controller or data processor. So let's begin with the data controller first. So under the definitions of Thai PDPA, it means any persons or an entity which has the power to make a decisions regarding the collection, use, and disclosure of personal data. Opposite to the data processor has no control, I would say. They cannot make a determinations on the collection, use, and disclosure of personal data. The data processor only follow the instructions or act on behalf of the data controllers. So this is the key factor that you need to take into consideration when you identify yourself, whether or not you have a control over the collections, use, and disclosure of personal data. So Welpen, you can add more on the Vietnam side. Yeah, please go ahead.
So similar to Vietnam, right? So the key concept of the controller here is that who have the right to determine purpose of the data processing, that one will be controller. And for the processor, it's just like the person that process information on behalf of the data controller. The data processor does not have the right to determine on the purpose or the mean of data processing activities.
Yeah. For example, you as data controllers, you collect the personal data of your employee, for example, and you don't have a payroll within the company, and you need to outsource the service providers, the third party. In that case, you need to share or transfer the personal data of employee to the third party, right? And that third party, I mean the service providers, the payroll service provider, have to follow your instructions, right? To provide the payroll service, to make a payment to your employee. So in that case, the payroll service provider will be considered as data controllers because they have no authorization or no control over the data. They have to comply or follow your instructions. That's it. That's how we identify the role of data controller and data processor. This is very important one, as I mentioned earlier, because under both law, there are certain set of obligations for each role. This is very key, like key concerns for every company who fall under the definition of data controller and data processor, and of course fall under the scope of the PDPA and PDPD under Thailand and Vietnamese data privacy law. Okay, so next, let's move to overview of the key compliance under both Thai and Vietnamese data privacy law. So we try to make it easy to understand. So we make it as a data flow, and we mentions the key issues or key requirements for each flow. So we divided the flow into 3 phases. The first phase will involve the collection of the personal data. The second one will involve about the internal management and use of personal data. And the third one will involve the sharing and transfer of the personal data. So let's focus on the first phase first. So for the first one, it's all about the collection, right? So there are certain key requirements that you need to take into considerations if you collect the personal data from the data subject. First, you need to identify the lawful basis, or you need to identify the purpose for the collection of the personal data. This is very important one. And the key highlight is if you need to obtain consent, you have to make sure that consent is valid and binding between you and data subject. This is also the key issue for Vietnam as well, right? Well, Pen, you can add a little bit more on that. Yeah.
Yeah. So when we talk about the lawful basis in Vietnam, right, it's that Vietnam is really formalistic country, like everything have to be based on the form or the clear instruction from the authority. So when it's come to the lawful basis, so Vietnam just like really clear that we are the consent-based country. So it means that like whatever you're going to do with the data, personal data, right? Whether you're going to collect, you process, transfer, store, or share to third party, you need consent from the data subject, unless there is any exemption to that consent requirements. And then the exemption under Vietnamese law is really limited. There are only 5 exemption for the consent. So first one for vital interest, right? In case of emergency, if the data subject is going to die or have a very serious health condition, so you can process that information without consent. And then second one will be in the emergency cases, like the state emergency cases, for example, if they have any like event related to disaster, national disaster, or there is any like protest or terrorist action, so that one can be processed information without consent as well. And then related to the company, right, it can have consent related to contractual obligation of the data subject. Like under the contract, if the data subject have the right and obligation to provide certain information to the company can collect it without any additional consent. So there will be only limited like consent exemption. So I think like for ease of understanding, I think we would like to emphasize that like mostly if you want to process personal information under Vietnamese law, you need to ensure that a valid consent has been obtained.
Yeah. So this is quite different from Thailand perspective in terms of identifying the lawful basis. For Thailand, consent is one of the lawful basis that are available under the law, I would say. This is quite similar to GDPR because you have the option to choose as well, but depending on the processing activities as well. So it's limited to the purpose of the collection of the personal data. So you can think of complying with the legal obligations or comply with the contractual obligations, something like that. So it's just quite similar to GDPR. So consent is not the king, I would say. It's not everything because some of the companies, some of our clients still understand that they need to collect or obtain consent from the data subject. Yes, which in practice, it is not true. So you can still opt to select other lawful basis as well. But again, depending on the processing activity or the purpose of the collection of personal data. Okay, so this is the first issue. The second one is about the notification requirements. I think all of you may know about these requirements. I would say because you may already seen this obligate like I think you may already comply with obligation already. So this obligation is something that you need to provide certain information regarding the processing of the personal data of the data subject before or at the time of the collection of personal data. So normally it's in the form of privacy policy or privacy notice. And I understand that under both laws, they require to have certain information to be included in the privacy policy or privacy notice. So I would say that there are certain set of information that you need to be included in the document, right? And for example, you need to explain what information or what personal data you will collect from the data subject, for what purpose, how long you're going to retain that personal data within your organizations, and what are their rights. For example, this is quite similar to Vietnamese data privacy law as well. And you need to notify this set of information to data subject before or at the time of the collection of personal data. This is very important one, just like consent as well. If you need to obtain consent, you need to obtain consent before or at the time of the collection of personal data as well. And it's depending on the communication channels that you normally communicate with your clients or your, data subject. So for nowadays, so many business operators have various channels that they communicate with data subject, right? Both online channels and offline channels. So you need to design the mechanisms to notify and or obtain consent from the data subjects, depending on the communication channels that you have. So for example, if you have website or online applications on the mobile phone, you may need to think of providing the link to privacy notice, or you may opt to provide a full documents of privacy policy in that applications or on the website as well. This is very common for online business operators that they do nowadays. So as you may see, every website do have the link to their privacy policy on the platform, right? For example, cookie banner, they do have cookie banners, they do have cookie policies, and they do have privacy policy for users, for customers that are available on the websites. This is one of the example. And to comply with the notification requirement, again, you need to make sure that your documents, privacy documents, include a minimum requirements of the information that the law require to have in that document. And second, you need to ensure that you notify to the data subject on the right time, right? Before or at the time of the collection of personal data. This is very important one. And the third issue is about the collection of data from minors. This is a bit tricky for Thailand, I would say, because there are two groups of minors. The first group is the minors who not exceeding 10 years old. And the second group is over 10, but less than 20. If your company as a data controller have to obtain consent from minors for the first group, you have to collect consent from their legal guardians or their parents only, I would say. But for the second group, if you need to rely on consent and they are not fall under any exemptions, you need to obtain consent from both minors and their legal guardians or parents. This is a bit tricky that I mentioned earlier. Is like very confused for our client as well when they handling with minors' personal data. So I'm not sure whether there are different perspectives from Vietnam side. So I will let Valpen explain a bit more about the collection of minor personal data. So please go ahead.
Yeah, so minor consent is also an area of problematic in Vietnam, right? We also have the age threshold as well, but the age is 6. Like if the children is under 6 years old, we only need the parental consent only consent from the parents. But if the children is between 6 to 16 years old, we need double consent. So first one from the parent and second one from the child itself, right? And then this one is very problematic because like I understand that nowadays like every company or every service provider that provides service to the children or other user, right? So they would like to simplify how they obtain consent, but this is the way it is. Like in our jurisdiction, that you need to obtain double consent for a certain period of minor. Yeah. And in addition, like the Vietnamese law, they also require the data controller who have the obligation to obtain consent to verify age of all data subject that they collect personal information. And then the law is silent on how the company going to do the verification process. Normally, the company will just check with the ID card or like if they have database related to age of their user or the data subject already, so they can cross check with that. That would be sufficient as well.
Yeah. This is very tricky one, as mentioned.
And problematic.
Problematic for both country, I would say. And the next one that relating to the collection of personal data is collection of personal data from other sources. So this is very common for nowadays. So you may not have a chance to collect that the personal data directly from data subject, right? For example, the company as like an employer would like to recruit new employee. They may reach out to a recruitment agency and ask them to collect personal data from the candidate. So in this case, they will not collect the information or the personal data directly from the candidate, right? Because they ask recruitment agency to collect the personal data for them, for the controller, I would say, for this scenario. So the law also have this requirement as well. When you collect the personal data from other source, for in this case, the other source mean recruitment agency. So if you need, and I think the issue is that if you need to rely on consent, you have to make sure that you will obtain consent from the candidate before or at the time of the collection of personal data. So normally we do recommend our clients to like negotiate with the recruitment agencies, whether or not they can help, they can assist in notifying and obtain consent for the company as an employer. This is very common one that we normally advise our clients. So let's hear from Vietnam perspective, whether or not you have a same mechanism for your client. Yes.
Yes. I mean, this one is not a specific requirements under the law or anything, but what the company should understand and try to protect itself is that before they're going to receive information from any third party, or to ensure that after they receive, they have the right to process in accordance with the purposes that they intended to do. So they need to ensure just two things. So first one, because they don't have the direct contact with the data subject, right? So they need to ensure that the consent that the third party that supply the information to them already obtain consent for them, for the company to further collect and process the data. And second one, very important, like, because we also need to like obtain consent for specific purpose, right? Only consent is not sufficient. You need to ensure that the consent that obtained is also include consent for all the data processing activity that the company intended to process the data. So basically, just 2 points, like first one to obtain consent, and second one, the very easy way is that like they need to ensure that the third party, when they obtain consent, they provide a copy of privacy notice of the company for the data subject to review and make consent to that privacy policy. So in that case, the company can ensure that once they receive the data, they will have the legitimate legal basis for further process the data as they intended.
Yeah. Another common example is when you engage an insurance company, right? You buy like insurance policy from them, and they need to collect the data from your employee. So as a data controller, so insurance company will also consider as data controller, and they need to comply with the law as well, especially on the obligation of the notification requirements and or consent requirements. So in this case, just what Valpen just mentioned earlier, they can provide their copy of privacy policies along with consent form and attach to their applications, and just to make sure that the company, the employer, obtain the consents and notify their privacy policy for the insurance company. This is just another example for your reference. So this is all key issues for the collection of personal data. So now we move to the second phase for internal management. So under both law, there's, as I mentioned earlier, as a data controller, you have certain set of the obligation, right? And for the internal management, you need to consider whether you have a security measure in place, you have a monitoring system for erasure or deletions of personal data, and to manage the data breach incidents, right? And also data subject right management as well, because under both law, the law provides certain rights for the data subject to exercise. For example, the right to withdraw consent, and the data subject can ask the company as a data controller to delete, destroy their personal data, subject to certain conditions and criteria set out under the laws. Another one, as a data controller under Thai law, you may need to have a ROPA, record of processing activities. This is quite similar to GDPR. So if you fall under the criteria to have a ROPA, you need to prepare like a record of processing activities. Every processing activities that occur within the organization, you need to record every processing activities, because this document can be reviewed by the local authorities, and the data subject can also ask for the review as well. This is the requirements under the law, which is like different from Vietnam, right? Valpen?
Yeah, I think in Vietnam, we are more flexible in terms of ROPA. It's not required under the Vietnamese law at all for the like controller, processor, or to prepare ROPA. But we have another filing requirements about data impact assessment, but I think we will discuss this later. But for ROPA, no for Vietnam.
Yeah. And lastly, appointment of DPO. Again, if you fall under the criteria to have a DPO, you need to appoint a DPO. And under Thai law, the DPO can be like an employees or external parties. And this is different from Vietnam. The DPO need to be employee, right? Valpen?
Yeah. So it's recommended, highly recommended by the authority that the DPO, right, data protection officers, need to be like someone within the organization. It doesn't need to be within the local company. I mean, if the whole group company, right, they have the global DPO, so the person can be in charge for Vietnam as well, just someone within the organization.
Yeah, and for Thailand, both data controller and data processor, if they fall under the criteria to have a DPO, they need to notify the DPO to the local authority as well. And this already effective since 13 December last year. So the company that required to have a DPO need to notify their DPO to the local authority by submitting the applications along with the supporting documents in Thai, I would say, because the authority prefer to have all communication in Thai. So the application forms available on their website is in Thai. So this is one of the key concerns for our client as well, mostly for foreign clients that they need to submit the applications. And next, let's move to the last the last phase, the third phase for sharing and transfer of data. For sharings, I would like to focus on the relationship between controller and processor. As mentioned earlier on the scenario of the company as an employer sharing the personal data of their employee to a payroll service providers. In that case, the law requires the companies to have an agreement, I would say, with so-called data processing agreement, right? And you need to have a DPA put in place and make sure that the DPA set out the obligations and responsibilities between the parties, especially on the obligation of data processor. This is very you need to consider when you engage data processor. But for C2C relationship, I mean controller and controller relationship, the law does not require to have an agreement, but in practice, like best practice, we do recommend to have an agreement as well to set out again obligation and responsibilities among the parties to make sure that they will comply with the data protection law both in Thailand and Vietnam. And Welpen, again, you can share your thought and the Vietnamese perspective. Yeah.
Do you want to discuss
before I
now?
move to
because I think we prepared,
we can discuss. Yeah, we can discuss later. Yeah.
Yeah. Just
Sure.
very detailed
Sure.
slide related to cross-border transfer.
Yes, indeed. Yes. And the last one is about cross-border transfer. So anytime you need to transfer personal data to overseas, you need to consider that both law do have cross-border data transfer requirements, and we will discuss further in section 2 as well. Okay. And this is about the extraterritorial effect, which I think you need to take into considerations, because even you don't have an establishment in Thailand or Vietnam, you may still need to comply with the Vietnamese or Thai data privacy law if you involve certain activities. For example, in Thailand, it's similar to GDPR, I would say. So if data controller or processors residing overseas but offer good or service to data subject in Thailand, regardless of whether payment is made or not, or monitoring behavior of data subject in Thailand, you may fall under the scope of the PDPA, which means that you have to comply with the obligation that I mentioned in the previous slide. And in addition, as an overseas data controller and data processor, you must also appoint a representative in Thailand in writing. If you involve a large scale of personal data and you also processing the sensitive personal data, this is one of the key requirements as well. If you are foreign data controller and data processor. Next, for Welpen.
Yeah.
Please go ahead.
So, yeah, similar to Thailand, like in Vietnam, we also have like extraterritorial effect, right? So basically it just means that like the law apply to both domestic company and also foreign or offshore company, like equally, to the extent that the company directly involved with the data processing activities in Vietnam, or even not directly involved but related to the data processing activities in Vietnam. That will trigger the requirements and require the company to comply with the requirements under Vietnamese law already. Like one of the example that the law provides is that like in case you are offshore company, right, you don't have any local establishment in Vietnam, but you have an online website or online portal, online database that use an automatic data system to collect personal information in Vietnam, right, from that overseas server or platform. In that case, it's considered as the person is involved in directly involved in the collections of personal information in Vietnam and subject to the requirements already. Like in terms of representative, whether like a company located overseas, right, need to appoint any specific person to be in charge for data processing activity related to like the Vietnamese citizens or not? The answer is no, right? Unless the company involved in the collections of sensitive personal data, right? Like for example, the financial information, the health information, biometric information. In that case, it will trigger the requirement to appoint a DPO in Vietnam. And like we mentioned before, like when it's come to the DPO, right, there is no specific qualification for the DPO. The DPO can be any nationality. It can be Vietnamese nationality, or it can be like foreign nationality. But the person need to be like retained or employed within the organization. That is the requirements. And there is also a requirement to notify the appointment of DPO to the authority, and that one will be take part, like the notification will take part within the impact assessment that the company need to require to be prepared and also submit to the authorities in Vietnam. Yeah.
Okay, let's move to the second sections, the key strategy and best practice surrounding the key concerns. So the first one is about how to identify the role of like data controller and data processor. This is like a FAQ from our client as well. So the first one is, can a company be both data controllers and data processors? And as I mentioned earlier, identifying the role of data controller and data processor is really important, because these both parties do have certain set of obligations that they need to comply with under both law, right? And again, for Thailand to identify whether or not you are data controller or processor, the key factor is that whether or not you have a control over the collection, use, and disclosure of personal data, or you just follow the instruction or act on behalf of someone. If the latter, you are just a data processor, not a data controller, because you have no authority, no control over the processing of personal data. So when we determine whether or not the company is considered as data controller, we normally focus on key factor. The first one, whether or not you have a power to decide what type of personal data should be collected. Second, you will have the power to specify the purpose for the collection of personal data. Third, you have the power to decide which data subject you will collect the personal data about. And the last one, you do not act on behalf of someone or follow their instructions. This is very key point, as I mentioned earlier. And back to the questions, can a company be both controller and processor? The answer would be yes, but subject to certain cases. Because in one processing activity, the company cannot be considered as controller and processor, cannot for Thailand. But I will let Welpen explain in more detail about data privacy in Vietnam, whether there is the same perspective or not. Yeah. So would you mind, Welpen?
Yeah. I think it's the same. Like, first of all, it's very important. Yeah. In general, right, it's the same that like the company need to identify, right, whether the company will act as a controller or processor. And in Vietnam, it's just like based on whether the company have the right to determine purpose of data processing activities or not. So in the role that the company have the right to determine the purpose of data processing activity, the company will act as a data controller. But in the case that the company only perform the data processing activity on behalf of third party, they will just act as a processor. This question very simple for the company that provide like services to third party, right? And then we will consider, like for example, if they collect information of their employee, in that case, definitely they are going to be the one who determine what they're going to what kind of data they will collect from the employee and what purposes. And in that case, they will act as a controller. And on the other hand, when providing services to third party, for example, like if the company provide cloud services, right? So they may have like the right to retain information of their customer. In that case, they cannot do anything with such data of the customer, right? Unless the data processing activity is authorized by the data controller. And in that case, they don't have the right to determine the purpose of data processing activity. So they will be considered as data processor in that circumstances. So here come, when it comes to the question whether the company can take two roles, yes, why not? That depending on the role and circumstances.
Yeah. Next is about the data minimization principle. Can the company collect any category of personal data? So again, collect as necessary as possible. So to comply with the data minimization requirements, you need to consider whether you have a lawful purpose to collect the personal data. Because when we conduct the gap assessment for our clients, we normally found that every client collect various personal data without purpose for the collections. This is very serious issues, because once you cannot identify the lawful purpose or the lawful basis for the collection of the personal data, it means that you breach the requirements of the law and lead to the penalty and liabilities under the law, which we will further discuss in the last slides. Yeah, this is very serious issues and very a key concern for every company that subject to data privacy law in Thailand and Vietnam. So to answer this question, the question, of course, no, right? Similar to Vietnam, right, Welpen?
Yeah, so Vietnam also
the answer
have
would be no.
very short and simple question is that you need to consider the data minimization, right? Only collect the information that necessary and adequate to the data processing activities and purpose that going to be performed by the company. You should not just collect any information, because it will put a burden on the company as well, to ensure that once you collect those data, you have adequate cybersecurity measure to protect the data. If it's not sufficient and data is leaked or breached, so you will have the responsibility to notify to the relevant party, the regulator, the affected individual. So it will put more burden on the company.
Yeah.
And then just one note for Vietnam, basically you can collect various type of information as long as it's necessary for operations of the company, right? But what I would like to draw your attention is that if you're going to collect information, you should know whether the data you collected is basic personal information or sensitive personal information, because once you collect the sensitive personal information, it will trigger the requirement to appoint a DPO. But in terms of processing of these two data is quite similar, but you just need to have a DPO in Vietnam. For Vietnam, not in Vietnam.
Yeah. Again, if it is not necessary, don't collect it. That's it. That's very simple rule, I would say. Yeah. So for our client, for example, HR department, they do have a application the candidate for the candidate to fill out, right? And they set certain clauses that require the personal data from the candidate, and some of them may not relevant to the purpose of the collection of personal data. For example, some company asks for line account, for example, or some company asks for their health related issues or history of their health conditions, for example, which sometimes not relevant to the position that they apply for example. So if the company collect them without lawful purpose, it will lead to a non-compliant issue that I mentioned earlier. This is one of the examples that we found. Okay, next, is consent always needed? Actually, I think I already provide my answers when we first talk about the flows and the key aspect in previous slide. So the answer for Thailand is no. no need, but depending on the processing activity and the purpose for the collection as well. So under Thai law, there are certain options, I would say, options for the company to select whether or not they will rely on the lawful basis. So under Thai law, we have like other than consent, we have legitimate interest, we have in legal obligations, contractual obligation, vital interest as well. So it's depending on the purpose of the collections, and to identify a lawful basis is very important, because if you have to rely on consent, you need to have like a valid consent, as mentioned earlier. So you may need to have a consent form. You need to have like a parental consent, as mentioned earlier, if you are dealing with the personal data of the minors, something like that. So it is very important because it will shape your obligations under the law when you selecting the lawful basis. So you need to first assess and identify appropriate lawful basis for each processing activity. Like, for example, if you collect the names, email address, or contact information of the candidate, you may rely on legitimate interest. For example, you don't need to rely on consent. But if you would like to collect sensitive personal data from the candidate, in that case, you may need to collect the explicit consent from the candidate. So you need to have a consent form and obtain the consent before or at the time of the collection of the personal data, blah, blah, blah. This is very important one to assess and identify appropriate lawful basis. And process personal data only if appropriate lawful basis can be identified. This is very important, just mentioned in previous slide as well. So collect the information as necessary only. Yeah. So let's hear from Vietnam perspective in relation to the consent, because it's totally different, right? Yeah. Okay. Please go ahead.
Yeah. Like in this perspective, Vietnam is the other way around. Like we love consent. It's necessary to obtain consent unless you can identify that there is any exemption applicable to you. And then, like I mentioned before, like for a company, right, there is only three types of exemption. So first one, vital interest. Second one, in case you need to disclose information in accordance with the law, right? If the law requires you as a data controller to disclose information to the authority, like during your business operation or something. So this one can be consent exempted, but otherwise, like consent still required. And the third exemption that the company can explore is about the like contractual obligation of the data subject only. I would like to emphasize that it's not everything contained in the contract, right, can be consent exempted only in the case that the data subject have the obligation to provide the information to you. Like, for example, like if they're employee, right, require under the employment law to provide like contact details, emergency details, or health related information to the company. So in that case, the company can collect the information without consent. But if the company going to collect like additional information, which is not required by law, right? So consent still required. Yeah.
Yeah. One thing that you need to keep in mind, consent can be withdrawn anytime. So that's why I say that you may need to consider other options when you collect their personal data, because as I mentioned earlier, for example, one of my clients only collect consent from their data subject. They just rely on consent, which is very risky for them because the data subject can withdraw their consent anytime. And when the data subject withdraw consent, it means that there is no long, like they can no longer process that set of personal data. And they need to somehow delete or destroy that personal data as well. So yeah, this is like the key issue and key concerns for every company.
Yeah. Yeah, so I think in this sense, in case the data subject would like to I would like to add something about Vietnam, right? So it happens also when the data subject would like to withdraw consents in Vietnam, right? So in that case, we will advise the company that they should explore if there is any other exemption that they can continue to process the data without consent. But unfortunately, the exemption will be in very rare and limited cases only. So it will be available only in the case that the company need to continue to process to comply with its requirements under the law, or to comply with the obligations of the data subject. Only in that case that the company can still process the information. But once they withdraw, because we don't have any many exemption under Vietnamese law, right? We have the law require that the company need to inform the data subject on the consequences of the withdrawal of consent. For example, if the data subject is an employee, right? So if the employee would like the company to withdraw and delete their information, the company have to notify them that without the data that the company need to process, they can no longer maintain the employment relationship with the employee, and consequences is that they may need to terminate the contract or something. In the same way with the service, right? And the customer, if the customer would like to withdraw the consent, and that will be insufficient for the company to continue to provide the service to the customer. So the customer have to aware of this one. And if this withdrawal of consent create any damage to the company can claim for compensation on the customer as well. There will be more details on the consequences that the data subject have to take responsibility as well.
That is civil liability, right?
Both civil and also mostly civil, related to loss and damage.
Okay. So next, how to get a valid consent. So again, consent has a formality under the law, both law, I would say, under Thai and Vietnamese data privacy law. So you need to have a written consent, whether or not it can be in any form, online form, or a physical format, like a paper consent form. It depending on, again, communication channel that you have, or a normal communications that you have with your data subject. So for example, the employee or candidate. So if you provide channels for submitting the application via online and offline, you may need to think of e-consent and paper consent form, and providing to data subject before or at the time of the collection of personal data. This is very important. So what you need to do is to clearly specify a specific purpose for which consent is required in the consent form, and provide consent request form in English for the foreigners, and for Thai or Vietnamese, we highly recommend to have a local language as well. This is not a mandatory requirements. There is no requirements regarding language to be used for the consent, but you need to make sure that the data subject fully understand what information that you communicate to them. This is very important. That's why we normally recommend our clients to have a local language for data privacy documents. And using untick box, this is very important issue as well, because some of our clients still understand that pre-tick box is permissible and applicable under the law. So I would say it cannot do that, because you need to make sure that the data subject can freely give in their consent and affirmative action as well. So we do not recommend our clients to have a pre-tick box to obtain consent. So let's hear from Valpen in case you have any additional information that you would like to add. Please go ahead.
So Vietnam is very formalistic when it comes to how to obtain consent, right? So there is several bases that the company need to ensure, right, that the consent is like correctly obtained and have validity once it's obtained. Like the first one, like the data subject need to be volunteer, right? The consent need to be voluntary basis, like, and silence or implied consent is not acceptable under Vietnamese law. The data subject just need to like express some kind of action for the company to ensure that like this is their action for accepting or providing consent to the company. And second one, it need to be informed consent, like is willing to the privacy notice that we discussed earlier, right? Like before giving the consent, the data subject need to be like provide with the like mandatory information as required by law, so they understand that what kind of data going to be collected by the company and what kind of purpose is going to be processed, who will be process their information, and if they have any issue related to their data processing activity, who they can contact to. Like there will be like a lot of information required to be contained in the privacy notice, right? And then the form, right? It need to be affirmative, and it can be in the checkbox. It can be voice recording, anything, but it need to be a recordable form for the consent. And most importantly, we need the answer is no, right? There is some kind of flexibility in how the company will obtain multiple consent, right? Like in this case, the authority in Vietnam, right? They have declaration. And for the question whether untick box is sufficient or acceptable under the law, first of all, the law is silent. The law is not explicitly prohibit the pre-tick box, right? And then the company have to ask itself, if it's pre-tick, does it allow the data subject to like provide the option for them to choose to untick or not? Or at the end of the consent form, do they have to click agree again? So if there is a mechanism to show that the data subject have the right to choose to untick if they want to, and then they express their consent again by like clicking I agree box right at the end of the like consent form, that would still be considered as sufficient under the Vietnamese law. Yeah.
Thank you, Welpen. So next issues is the consent, the same as the privacy policies. So this is like FAQ again. So many of our clients always ask that, is consent is the same as the privacy policy? So the answer is no, it is not like the same document, but actually it can like combine in the same document, but you need to separate sections to avoid misunderstandings of the data subject, I would say. So it's actually a completely separate obligations of the data controller, as mentioned earlier. So if you need to obtain consent, so you need to make sure that it's valid consent, as mentioned in previous slide. And for the privacy policy, is to make sure that you comply with the notification requirements that I mentioned earlier. And here is the full list of the information that you need to consider when drafting the privacy policies under Thai and Vietnamese data privacy law. So at least you need to provide like information relating to the purpose of the collection of personal data, category of personal data, retentions, relevant parties or person that personal data will be disclosed to, right, of the data subject, information relating to the data controller, something. Yeah, this is like the set of minimum, I would say, minimum informations that you need to include, that need to be included in the privacy policy or privacy notice. But the question will be raised when the privacy policy need to like have to apply for multiple jurisdictions. So when it's come to the issue of like global privacy policy, so many of my client again think that the global privacy policy can apply directly to certain countries. But the answer for Thailand is no. You have first to make sure that the global privacy policies already comply with the local requirements. Especially, you need to ensure that the information required by law are already incorporated in that document. But normally what I found, the information is still missing in the global privacy policy. So we normally advise the clients to have a specific addendum for Thailand, I would say, and Vietnam as well, right? We do recommend that.
Yep.
And this is very practical for every country. Yeah. Okay, well, Pen, you can add on that if you have. Yeah.
Yeah.
But you do the similar mechanism as well, right?
For
the global privacy.
Yeah. Yeah, we have a checklist, and then what included in the checklist, right? So it will be the mandatory information as required under the local law or Vietnamese or Thai law, right? So we have to check whether like the data, the privacy policies of the company contain all the informations or not. And then when it comes to localizing the privacy policy, right? We found that mostly the company does not have information related to like potential unexpected consequences or damage related to data processing activities. We understand that this is not required under GDPR, and this is one of the unique information that required under the Vietnamese law. So basically, it's always a best practice that you have the like global privacy policy to review and localize for Vietnam.
Yeah. And regardless of whether the lawful basis you rely on, you still need to notify this set of information to the data subject. So for example, if you don't need to collect consent, but you can rely on legal obligation, you still need to notify the privacy policy to the data subject. This is very important one. And the second point, can the privacy policy be provided through a QR code, a link, email, or SMS? Again, depending on the communication channel that you have or you made available to the data subject. Yeah. This is like very common for nowadays that the business operators do have a like various format of privacy policies for their data subject. Again, depending on the communication channels. Valpen, would you like to add any point before I move forward?
Yeah. How you're going to notify the data subject is totally depends on the options of the company, right? The law just would like to care that as long as the data subject have been notified with the mandatory information is sufficient, regardless of whether it will be notified through electronic form or through paper form, or but cannot be verbal, cannot be in verbal form, just like in the written form, but whether it will be notified electronically or on the paper basis. So it's acceptable or acceptable.
Yeah. Thank you. The next issue is, can personal data be transferred to other countries? This is like quite a key issues as well nowadays, because data can be transferred to like any other third parties outside Thailand. And this is very common practice as well for the business operator nowadays, that they do share their personal data amongst their affiliate or group companies, or even with other third-party service providers. So yes, for Thailand and actually Vietnam, we do have requirements for transferring data to other countries. The general requirement is that you have to make sure whether or not the destination country do have adequate personal data protection standards. For Thailand, the local regulators will issue a whitelisted countries for the data controller and processor for reference when they transfer personal data to other countries. So just make sure that the destination country have a adequate personal data protection standard that would be fine, or unless exempts or fall under the exemptions under the law. For example, if you already know that you transfer data to the country that do not have data protection law, you can ask for consent from the data subject. This is one of the available options and exemptions for cross-border data transfer in case the destination country doesn't have adequate personal data protection standard. And other mechanisms that are available for safeguarding cross-border transfer under Thai law is binding corporate rules, of course, just like similar to GDPR, and also appropriate safeguard. For example, standard contextual clauses. And a good news is that Thailand's adopt the concept of BCRs and SCC model under GDPR. But if the company would like to select these options, like either of these options, you need to make sure that the contents in the BCRs or your SCC clause do contain certain information that require under Thai law. Yeah, and actually the BCR need to be submitted to the local authority for their review and approval. And again, it needs to be made in Thai. So if you have an English version, you have to translate it into Thai before submitting to the authority. This is quite like a key concern for our foreign clients. And yeah, this is all for Thailand. So let's move to Vietnam. So Pen, please go ahead.
Yeah, so in terms of cross-border transfer, right, to transfer information from Vietnam to overseas, the requirements totally different from Thailand. Like we have specific conditions that the data transfer need to comply with if they want to transfer the data, right? So first one, the data transfer, regardless of whether they transfer as a data processor or data controller, they need to prepare the cross-border data transfer impact assessment and then file it, we call in short TIA, right? And then the company need to keep one copy of the TIA at the company at all time, and then file another copy to the authority within 60 days after the first date of transfer. And then there will be like very detailed requirements on how the company going to prepare TIA, right? And like, for example, they need to disclose information that like who is the data transfer in Vietnam and who are the data transferee who going to receive the data outside of Vietnam. What are the purposes of data transfer, and also what will be the data transferring activities going to be performed. Like there's a lot of details in this one. And then the second requirement, you need to prepare the data transfer agreement or DTA, right? To like have the right and obligations of each party, the data transferer and data transferee, to be set out under the DTA. But the Vietnamese law, they don't set out any specific clause or the like standard contractual clause or any specific details that need to be required to be input into the DTA. So it's silent and it's up to the company on how they're going to like provide information under the DTA. And then the third requirement is that you need to ensure that the data subject has consented to the cross-border transfer. So in this case, when you obtain consent from the data subject, it is always recommended that one of the purpose that you declare to the data subject is that like you're going to transfer information to third party outside of Vietnam, and for which specific purpose. This one need to be declared in the like privacy policy. And the last one, once the transfer is completed, the first time, right? Once the transfer is completed, you need to notify the success of the transfer to the authority. So this will be the condition for the transfer. And then Another question, has the authority have the power to request the company to stop transferring the data? The answer is yes. The authority have the right to request the company to cross-border transfer the data if there is a ground, like set out by law. The first ground, if the authority found that the purpose for the transfer is against public interest or national security of Vietnam, right? So in that case, the authority have the right to request the company that we are no longer allow you to like cross-border transfer the data, and all the data must be retained in Vietnam. So this is possible. And the second one, the transferor, they fail to comply with the TIA requirement. They not prepare the impact assessment and file to the authority. This could be another ground for the company, for the authority to stop the cross-border transfer. And the last one, if later on there is any incident related to the data transfer overseas, right? And it's found that the company have failed to provide any adequate data protection related to such data breach. The authority can use this ground to prohibit any further cross-border transfer transactions of the company. Yeah.
Yeah. Actually, the TIA is quite a big issue in Vietnam, right? So every company needs to do the TIA before, like when they transfer personal data to overseas for Vietnam, but not for Thailand. We currently don't have a requirements for data controller and data processors to conduct the TIA, but it's just a best practice for Thailand, I would say. And ROPA, again, for Vietnam is optional. So I will be the one who handle this slide. So just mentioned earlier, the data controller and data processors may need to have ROPA if they fall under the criteria set out by the law. And the ROPA is similar to GDPR. It's a record of processing activities. So it do contain certain information required by law. And yeah, it's normally contain everything relating to the processing of personal data, like personal data collected, purpose, detail of data controller, retention period, and etc. So this is something that you need to have apart from consent form, privacy policies, data processing agreements, DTA. That's just what Wellpen just mentioned earlier. So this is considered as one of the key documents, mandatory documents that the company needs to have within the organizations, because again, this kind of document can be asked for review by the local authorities and data subject. So this is the very important part that the company needs to have the ROPA within the organizations. Next, now we move to data subject right, which is like very important part of both laws, I would say. This is like the right of data subjects that the law grants to the individual. So the key concern and key issue is that how company or how data controller, I would say, how data controller can manage data subject right requests effectively. Because if you can imagine, they may, like for online business operators, in one day, they may like obtain or receive a lot of requests, data subject right requests, sending by an individuals every day. So normally we do recommend our client to have a separate portal for data subject right requests. And we do recommend the companies as a data controller to have a data subject right request form, which can be like online form or physical format. It's depending on the channels that you have with your data subject. This is like help the company as a data controller to manage the data subject right, and especially like it can be records and as an evidence in case the local authorities inspect the company operation regarding the processing of personal data, and importantly to ensure that you will fully comply with the local requirements under like both Thailand and Vietnam. And in addition, we do recommend our clients to have a guideline or handling policies in terms of managing data subject right requests. This is very important, but not mandatory, I would say. It is like optional documents that we normally recommend our clients to have within the organizations. This document will be beneficial for their staff, especially the one who handle the data subject right request. Because in that document, it will retain the process and details requirements that the company as a data controller have to comply with. Because each kind of rights of the data subject do have different conditions and criteria. Yeah, so to ensure the alignment of the compliant practice within the organization, we do highly recommend our clients who is data controller to have a guideline or handling policy within the organizations. This is very important one. And for Thailand, there may be a guideline or sub-laws to be issued in the future detailing about the conditions and criteria, and especially for the timing for responding to the data subject. So let's hear from Vietnam side for this topic, whether it's
Yeah. So in Vietnam, right, we have recognized 11 right? 11 type of data subject right. And then the main type of data subject right is just what we show in the slide here, right? Like the right to withdraw, delete, portability, and so on. And what would be the key information for Vietnam is that for some right, is required to the data controller to respond within a time frame set out by law, which is 72 hours upon receiving the request. So it's come to the issues again that the company or the data controller, right, should have the internal protocol when they receive requests from the data subject, so they know how to respond and can respond in a timely manner within the timeline set out by law. And similar to Thailand, there is a specific procedure required by law on how the data controller need to respond related to the request for data subject right? For example, like the right to delete. It does not necessarily that when the data subject requests for deletion of their data and the company need to always comply with such requests, right? There is an exemption under the law. There will be some circumstances that the law allow the company to refuse to comply with the request for deletion. For example, if the company have the legal obligation to further retain and process the data, in that case, the company can refuse to comply. And if it's is prohibited by law to delete the data, so this one can be exemption as well. And then what I would like to draw your attention to is the right to data portability. This kind of right is very unique in Vietnam, right? So the law requires that the data subject need to present their request in a specific form set out by law. And again, the form will be set out by law and in Vietnamese. So the company need to ensure that they have this form and then communicate to the employee that in charge of handling data subject right to also use this form when communicate with the data subject. And related to other rights, so similarly, it have specific procedure that the company should be aware and comply with in order to ensure that they not violate the violations of the law.
Yeah. And as mentioned earlier, some company do have a separate portal for the data subject to exercise their right, and the link can be included in the privacy policy as well, under the section of the data subject right, which is the required information need to be included in the privacy policy. This is one of the key strategies and best practice for the data controller to follow with. Yep. Next, actually last but not least is about data breach incident. So again, this is one of the key obligations of data controller. So if there is a data breach incident, the data controller have to notify. It is a data breach notification requirement, I would say. So the data controller have to ensure that they will notify the data breach incident promptly to the officers, the local authority and or data subject if required. So there are certain criteria and requirements for notifying the the officers and or data subject, depending the level of risk. So, but the key highlight that I would like to mention is that you need to do the assessment. The assessment is the key, the key factors to ensure whether or not the incident is considered as a notifiable data breach, right? So I understand. I think every company nowadays do have a protocol for handling with data breach incidents. And this is what we recommend to our client as well, to have a handling policy or guideline in case there is a data breach occur in the organizations. So we normally advise them to have a workflow within the organization. So when the data breach occurred, first they need to do the assessments to ensure whether or not the incident is notifiable data breach. If yes, does the data breach did pose a high risk or just a risk to the right and freedom of the data subject. So if there is a high risk to the right and freedom, they need, the company as a data controller have to notify both the officer and the data subject. And the timing for notifying the officer is within 72 hours upon becoming aware of the data breach. This is totally different from Vietnam. You will hear from Valpen. This is totally different. Yeah, but again, Thailand adopt the main principle from GDPR. So that's why we adopt 72 hours upon becoming aware of data breach. Yeah. This is very key issue. And the previous years, we in Thailand, we deal with more than 20 cases about data breach. We did help a lot of our clients to notify the data breach notifications to the authority and also to the data subject as well. So they don't have a formality of the data breach notification, but there is a requirement, especially on the required information that need to be notified to the data subject and the officer. So we do help the clients to prepare a data breach notification for submitting to the local authority and also notifying the data subject if required again. Yeah. So let's hear from Vietnam side.
Yeah. So Vietnam, right? I think one of the key issue that Nopara just mentioned is about the time frame, right? Even though it's 72 hours, the same 72, right? But the time is different. Like in Vietnam, we just count from the occurrence of the incident. But in reality, we can say that during the past year, right? So the data protection decree in Vietnam, it just take effect in 1st of July last year, 2023, right? And then a lot of companies have to comply with the data breach requirements. And then we have assist a large number of companies to comply with this one. And one of the problem is that they cannot make it within 72 hours because once they have been identified with the incident, right, or potential incident, they have to conduct the internal investigation, what kind of data subject will be affected by this incident and whether it's related to Vietnam or not, or the incident occur overseas, whether it have to be notified to the local authority, right? So the process take time, several weeks already, the timeline is passed already. So in reality, hardly ever that the company that can comply with this one. And then the authority, they're aware of this also, that it's difficult to comply. So what they provide the flexibility in practice is that if the company cannot comply within the 72 time frame, right, they can just like clarify the reason for the company that the company unable to comply with the time frame to the authority, and most of the time it will be acceptable by the authority. They will not impose any penalty or anything. And then the other key issues is that Vietnam have a specific form, right, for notifying the data breach incident to the authority. It is very detailed, and also because we have Vietnamese as an official language, so the reporting language need to be in Vietnamese. And then in terms of who we need to notify, right, like first you need to notify to the authority regardless of the level of risk, right, whether it will be low risk or it will be impose high risk to the affected individual. You need to notify to the authority. And similar to Thailand, like if it's imposed high risk,
Yes.
it will trigger the requirement to notifying the affected individual as well. And yeah, so this is, and then in case of low risk, right, even though it's not a high risk, but there is a specific condition. If the company provide telecom services or online services, there is a cyber security law separately regulate them to notify the affected individual as well, regardless of the level of risk. And also, you also have to check whether there is any sector specific law require the company to notify to the like specific regulator or the individual. For example, for the strictly controlled business like financial services, the banking payment service provider, they will have their own sets of regulation, and you need to also check with the sector specific law and regulation as well. And e-commerce as well, like e-commerce, you also need to notify the e-commerce authority in addition to the General Data Protection Authority.
Yeah, same as Thailand. So if you subject to any specific laws and regulations pertaining to specific sectors, you may like better check the regulation whether or not you need to notify a specific government body other than the privacy agencies in Thailand as well. And I think not last slide, the last two slides, I guess.
Last two.
The key strategy on last two, right? Okay. Who is the DPO? So this is like I think this is very common issues as I explained earlier in the first slide, not first slide, the second slide when we explain the key aspect of the legal requirements under Thailand and Vietnam. For the DPO, you may need to appoint a DPO if you fall under the criteria set out by the law, which means that the data controller, not every data controller and processor do need to have DPO. Yeah. So just certain DPO, certain data controller and processor that need to have a DPO. But when you have a DPO for Thailand, again, you have to notify the DPO to the local authority. Yeah. But yeah, unfortunately, the deadline is already passed, 13 December last year, but you can still notify the DPO to the authority because there is still no precedent case on how they're gonna enforce like for non-compliant if you need to notify the DPO to the authority. So I'm not gonna say we are in the relaxation period. But the sooner the better. Yeah, I would say the sooner the better. But because some of our clients still in the process of notifying a DPO, but we do recommend our clients to do it fast as soon as possible. Yeah, and the duty and responsibility of a DPO, I think this is quite similar for Thailand. For Thailand, this is quite similar to GDPR. So the roles of the DPO is to advise controller processors and their employees, their staff as well, coordinate with the local authorities, maintain confidentialities, and to make sure that they will comply with the qualification requirements to be issued under the law. So for Thailand, there may be a sub law requiring the certain qualification for the DPO. For example, the DPO may need to have certificate from the approval institution, something like that. So this is wait and see. So we normally issue a client alert and article normally every day, I would say. So yeah, please check our website. You can see a lot of article and client alerts. Yes. And normally for data privacy, we do updates as well if there is any development in this area. Yeah. And for the criteria for the DPO appointment, the criteria for the private sector. So if your core activities involved with regular monitoring personal data and or the system by reason having a large number of personal data, you have to appoint a DPO. And if the core activity involved with processing of a special category of personal data or sensitive personal data, you have to appoint a DPO as well. So for the third one, the core activity that relating to processing of sensitive personal data, the data controller normally will be a hospital, right? Hospitals or maybe pharmaceutical companies, because they're dealing with a lot of special category of personal data. This is really common one. Yeah. So again, the deadline is passed, and if you fall under the criteria to have a DPO, please make sure that you advise your clients, or if you are the controller or processor that's subject to Thai PDPA, you need to comply with this obligation as well. Okay. So I will pass to Valpen to talk on the DPO requirements under Vietnam. Yeah. Before we go to the last slide. Yeah.
Yeah, okay. I think we will go quick because we are running out of time. And then for Vietnam, there is only one criteria that if you collect and process sensitive personal information, you need to appoint a DPO and then notify the appointment to the authority. Yeah.
Okay. Okay. Last one. This is a liability and penalties mentioned in the law. So we actually it's the same as GDPR as mentioned earlier, but except for the criminal penalties, because Thailand, we do have criminal penalties for non-compliant issues, and the fines ranging between not exceeding 1 million baht and or imprisonments for a term not exceeding 1 year. And in case of legal entity like a data controller, the director, manager, or other person having responsibility for who act or fail to act, will they scare of this penalty very much, because they may go to jail, I would say. So this is very different from GDPR, totally different. Yeah, and we do have civil penalties, administrative fine. This is quite similar to GDPR. The administrative fine penalty is the range between 1 million to 5 million. And for civil penalties, the court may order punitive damages 2 times the actual damages. Yeah, this is for Thailand. And the key highlight that I would like to mention is about enforceability level. Since the PDPA already take fully effective since 1st of June 2022, and we already have a government agency, not government, sorry, the agency in charge, which is the PDPC, Personal Data Protection Committee. So the enforcement level nowadays is quite high, I would say. So there are certain, not precedent case, but there is a case that submit for their review. But there is not publicly available right now. They just a statistic show us that actually there is certain case that's already submit for their review and determinations. So this is a key highlight for all of you to know that we are now like the officer is now take it serious and they do take proactive approach because they do have an eagle eye team to like oversize like the operation of the company, especially for those who operate online. Yeah, so they can check whether or not you have a privacy policy available on the platform. So you have a consent mechanism to obtain the consent from the online user, something like that. They can do that. And especially for the data breach as well. Yeah. This is the key highlight for Thailand. So let's move to Vietnam. Yeah. So please go ahead, Valpen.
Yeah, so Vietnam for violation related to data protection, right? So we have like civil liability that the data subject can like claim for compensation for loss and damage related to like unauthorized or illegal processing of their data, right? And there is no punitive damage in Vietnam. Like this is a good news for the controller. And in terms of criminal liability, currently there is only one kind of like violation related to personal data that could be subject to criminal liability, which is the illegal trading of personal data. Like, for example, if you have a database containing contact information of your customer, and if you sell this one or provide it to third party for other benefits. So this one could be considered as like illegal trading, and it could be subject to the criminal liability. And the director or the managerial staff who responsible for the illegal trading could also be subject to the penalty as well. The penalty will be range from like administrative fine of up to like 1 billion Vietnam dong, or in terms of US dollar is like 42,500, right? And it also have like imprisonment penalty for up to 7 years. So this is the criminal liability. And in terms of administrative liability, currently, the government is drafting a new sanction decree to impose like all the like penalty for violations under the personal data protection decree. And this one is in its final stage to be finalized and take effect. And the tentative effective date is like in the middle of this year or in around June or July of this year. And then we foresee that once the new sanction decree take force, right, there will be a stronger enforcement by the authority. Like actually, like in earlier this month or the end of March, right, last month, the authority or the Ministry of Public Security, who is in charge of data processing activities in Vietnam, they just like issue an investigation regime. They will like issue a letter to a selected company, right, in several sectors. Like there will be around like 40 or 50 companies subject to this round of investigation, and they will ask the company to declare information whether they have complied with the PDPD requirement, or if they have not complied, what is the reason for their non-compliance. And then because currently there is no sanction decree, so the authority cannot impose the sanction yet, but they just like ask the company to encourage them to comply. But we foresee that once the sanction decree take effect, we can see the enforcement like more strongly in Vietnam. Yeah. So this is for Vietnam.
Yeah. And actually this is the last slide. So this is all from us, both Thailand and Vietnam. Thank you.
Right. Well, thank you very much. Maybe you can go back to the slide up front with your introductions. So we have a couple of questions, and we're happy to, first of all, thank you for such an outstanding presentation, very comprehensive. We have one question that came early in your presentation, and you may have already answered this, but it was just a point of clarification from Thailand, and that is whether a payroll service provider is considered to be a data controller or a data processor. So, Noprat, can you clarify that one technical point?
Yeah, sure. So as mentioned earlier, you need to consider certain factors, whether or not the contractual parties, like in this case, a payroll service provider will be considered as data controller or processor. So first, you need to consider whether that person or that entity has the authority or the control over the decisions that they're gonna who gonna collect personal data, right? Because the payroll service provider cannot have that control for sure, because the company as an employer will instruct the service providers to pay, like make a payment to their employees. So there is no control over the decision that to be made, which is pertaining to the employer as a data controller. So in this case, considering the relevant fact, the service provider may be considered as data processor. Yeah, but again, it need to consider on the case by case basis, because sometimes the processing activities may be vary and sometimes the service provider can be considered as data controller as well if they perform their duty out of scope. Yeah, because under Thai law, if data processor process personal data out of scope, they will turn to data controller automatically. Yeah.
Yeah, and is there anything different under Vietnam practice?
Yeah, so I think in terms of like analysis, right? Like the way the direction is similar to Thailand, and I understand that it's different from the analysis under GDPR, because we also have the same question from the European customer as well, that like in the GDPR for the like service provider, they will be considered as independent controller. But unfortunately, under Vietnam or Thai law, we have a clear criteria, right, on how to determine. Like first one, if the company have the right to determine on purpose of the data processing activity, so that entity will be considered as controller. But when it's come to the payroll, right, like Nopara just mentioned, like the scope of data processing, it just limit to what is agreed to by the company, which is the data controller. And when the payroll service provider, they transfer the money, right, they transfer on behalf of the company. They're not transfer on their own behalf. So in this case, it's more likely to be considered as data processor under Vietnamese law.
Makes sense. Now, what you just said raises another question that I think may be useful to invite you to discuss very briefly. And that is that one of the challenges for Chinese companies, but also all companies that have operations across multiple jurisdictions, is how to try to harmonize their policies and practices. So what do you see are the best practices from leading multinational companies that Chinese companies might be able to learn from? So for example, is it common for multinational companies to use GDPR as the base, because that in many cases is more stringent, or at least at the leading edge, and then have addendum for each country, and then of course translation? Or how do you see that in Thailand and in Vietnam? What do you recommend for cross-jurisdiction management of data privacy rules? So
Yeah.
Nopara, you want to start?
I can go. Yeah, I can go first. Yes, I can go first. So as I mentioned earlier, a lot of our clients do have a global privacy policy or privacy notice, and most of them rely on GDPR model. Like a core body of the global privacy policy is complied with GDPR already. So what I mentioned earlier is we just add a specific country addendum, like for Thailand, because like there's still some missing information that required by a local law, and we need to communicate with our clients that okay, this global privacy policy is not gonna work like for Thailand, because they are still missing some like certain informations, and we need to have a specific country addendum. Yeah, this is what we normally recommend to our client. Yeah.
And you also have to have it in local language.
Like same.
Yes, local language. Yes, as I mentioned earlier, it's not. There is no language requirements under the law, but again, to ensure that the data subject will like fully understand what the company try to communicate with them, we normally advise our client to have a local language. Yeah.
All right. Well, thanks again. This has been a very informative presentation. Again, from one of our outstanding member firms in the SIPAC network. And again, our purpose at Lishan Jiangtan and through SIPAC is to provide more opportunities for Chinese lawyers engaged in cross-border transactions and compliance matters to have access to true experts around the world. And tonight was a very good example of that. Now, we're going to have another event at the end of May. And Yang Lu Shi on our team is now sharing over the WeChat video platform a flyer for our event in Hangzhou at the end of May. And this will be another event focusing on compliance, and we will have leading experts from the US, the UK, India, Japan, Germany, Netherlands, Russia, and others, including from China, all to discuss key elements of compliance management around the world. This is a unique opportunity where you will be able to come and meet many of these or all of these experts in person to be able to learn from them and learn international best practices in respect of compliance management. So we hope that you will consider joining us for that event. We thank you again for joining us tonight, and we look forward to having you join us in our next live stream webinar. Notices to come. Thank you again. Good night.
Good night.
Thank you. Bye-bye.
Bye-bye.